Good day to everyone, wherever you may be in the world. And a very warm welcome to all of you, all our distinguished panelists and participants. Thank you for being here with us today. My name is Ricardo Espinosa, and I am the director of the International Association for Human Rights Advocacy in Geneva. It's a real pleasure for me to open this first session of our public expert series on international human rights mechanism. This expert talk series is part of IAHRAG's core mission. In fact, our very first one, to share, promote, and defend human rights. We believe that open dialogue between experts, NGOs, and the public is key to building stronger, more inclusive human rights system around the world. To help lead today's discussions, we have invited one of our youngest but very experienced colleague to moderate the panel, Ali Oskan. Ali is our human rights officer. He has worked closely with UN special procedures, sharing both individual and collective cases of human rights violations. We are confident he will bring clarity, energy, and fresh perspective to today's conversation. With that, I will hand it over to Ali to start the panel. Ali, the floor is yours.
Thank you, Ricardo, for the kind introduction, and I extend my warm regards to everyone joining us today. Well, actually, it's truly engaging with the United Nations Special Procedure mandates is a meaningful part of my work as human rights officer. But having the chance to learn directly from three leading experts who shape and strengthen this system is a rare and rewarding opportunity for me. We have initiated this online panel at a moment when civil society actors and human rights defenders around the world are being asked to do more with less. More advocacy, more legal creativity, more protection work, more public visibility, but often in the context of reduced access, limited resources, shrinking civic space, and rising risks, including reprisals. Well, in this complex landscape, the United Nations Special Procedures, which has 46 thematic and 14 country mandates, remain one of the most dynamic and agile tools available to those who advocate for human rights. Actually, the independent experts have a rare flexibility within the United Nations system, which they can receive urgent communications, issue public statements, conduct country visits, and engage states directly, often when no other mechanism is moving. But while the special procedures are accessible in theory, in practice they can be challenging. Understanding the mandates, choosing the right entry point, aligning advocacy efforts with legal proceedings. It's a bit like playing multi-level chess in several areas at once. In this regard, I admit that strategic use of those tools requires legal knowledge, political awareness, and good timing. In addition, consistency and perseverance and a certain level of patience are required to achieve effective results that will bring about real change in the field. And also, amidst the challenges, there may be a lack of clarity around which mandates to approach and how to structure communications, as well as limited resources to sustain follow-up and advocacy. Many NGOs and civil society actors, especially smaller or grassroots ones, may struggle with language barriers, formal submission requirements, if exists, or simply the time and expertise needed to navigate the system. Even when engagement with special procedures is successful, responses from states may be delayed or politically ignored, making follow-up difficult and in some contexts risky, I would say. Furthermore, to be honest, navigating the special procedure system without experience and knowledge can feel like being thrown into an ocean without a map. So, how can we turn this ocean into a practical lake, especially for strategic litigation? Fortunately, today we are not alone in the ocean. We are hoping to address these questions and challenges with 3 experts, each bringing deep experience, internal insight, and good recommendations to help. In this regard, first, let me introduce Professor Margaret Satterthwaite. Professor Satterthwaite serves as the United Nations Special Rapporteur on the independence of judges and lawyers since 2022. She is Professor of Clinical Law at the New York University School of Law, where she directs the Global Justice Clinic and co-leads several human rights initiatives. With a distinguished career that includes litigation before international and regional human rights bodies, advisory work for the World Health Organization and World Bank, and decades of academic leadership, she brings a significant experience that spans both theory and action. Then it's my pleasure to introduce Professor Matthew Gillett, being member since 2022 and currently the Vice Chair of the United Nations Working Group on Arbitrary Detention. Professor Gillett is Senior Lecturer at the University of Essex. Professor Gillett is an experienced international lawyer and human rights specialist. He has investigated and prosecuted war crimes, crimes against humanity, and genocide for over 15 years. He worked as trial lawyer and appeals counsel at the International Criminal Court and the United Nations International Criminal Tribunal for the former Yugoslavia, and has conducted investigation in various conflict zones. And finally, I welcome Dr. Elodie Tronchet. Dr. Tronchet is senior lecturer at the United Nations Institute for Training and Research and also performs as human rights litigation advisor. She used to work within the Office of the High Commissioner for Human Rights as Human Rights Officer. Dr. Tronchet currently engages with civil society organizations and brings a strong strategic lens to using human rights, United Nations human rights mechanisms, including special procedures, effectively and creatively in long-term litigation. Now, before we begin the discussions, I would like to make just a quick reminder on the structure of the panel. After the presentations from each panelist, we will move into a moderated discussion, and then we will open the floor for a Q&A session. Actually, the panel is being recorded and microphones should be muted through the panel. And if you have any questions, please feel free to submit them via the chat, and I assure you we will do our best to address as many as possible during the Q&A session. Now, I am pleased to give the floor to Professor Margaret Satterthwaite. Due to her tight schedule, she will have to leave soon after her remarks. So I thank her in advance for her contribution and her time. Margaret, you have the floor.
Thank you so much, Ali. That was a very lovely introduction, and I want to tell everyone that I am in an airport. So I'm hoping that it won't be too loud. If you can't hear me, please put in the chat that you can't hear me so that I know that that's happening. This is a wonderful gathering, and I've been really very much enjoying seeing who's joining the discussion, and I'm sorry that I'll be missing the interactive part, which is always the best. So let me just dive right in. I'm really grateful again to be here. What I will do is kind of talk through the 3 main activities that mandate holders undertake and give you a little bit of thoughts about how to maybe be strategic with each of those 3 main activities. So I'm going to start with communications. So you probably know that communications are formal allegations that are in the form of letters sent to states or other actors concerning alleged violations of human rights. They can relate to individual cases or legislation or patterns of conduct. So we have 2 main kinds of individual cases, and then ones that are more about legislation and patterns. We also have something called an urgent action, which an urgent appeal rather, which is simply means that we can usually get it through faster because there's something that involves a very high risk to life or security of person. So the process is pretty straightforward. Anyone, an individual, a lawyer, civil society, can submit a communication or allegation. This is normally through the online form, or sometimes they come through by email. And you should include as much relevant information as possible there, trying to be very clear and objective with facts, legal context, identities of victims, and institutions that are impacted. And ideally, if you have some, you can give links to supporting documentation or include some of it if you would like to submit some of that immediately. And perhaps most importantly, for anyone who's an actual victim, we need to have consent. And there are some exceptions or ways to work with that requirement that you all can probably discuss during the discussion period. But it is important to know that we need consent for individuals. If the issue then falls within my mandate, and if there's a reasonable basis to believe that a violation has occurred or may occur, then we prepare what's called an allegation letter. And that has a very specific format that you can observe by looking at allegation letters that have been issued in the past. And it's helpful, I think, to look at that format so you can see how we approach those. Both the communication that we send to the government or the other actor, plus any response from the government that we might receive within a 60-day period, will be published after that 60-day period on the website of the High Commissioner for Human Rights. So why is this relevant, and what are some strategic thoughts? So first, communications really internationalize a claim. They can apply pressure on the targeted state or the actor that's responsible for the human rights violations. They can also help you establish an official record. And if you do your homework and work around it, they can also draw media and public attention. They can support ongoing legal strategies by adding international visibility, by helping to mobilize allies, and also by contributing to public or political pressure that you or civil society allies may be bringing through other means. And in addition, and I think in particular, if you're engaging in national litigation, sometimes communications can actually prompt states to make additional information available about a given set of violations. And I think Professor Gillette will have lots of thoughts about this because his mandate actually is much more effective, I would say, at this element than many other mandates. This is because communications contain a set of questions at the end aimed at clarifying the situation and understanding whether a violation has occurred. And this can be really helpful, or at least it can be revealing. And let me give you an example that I just heard about last week. The Special Rapporteur on Migration last week explained at a side event that El Salvador has replied to a recent joint letter that many of us sent concerning the migrants who were recently sent by the United States to El Salvador. In its reply, he explained that El Salvador stated that it does not have jurisdiction over the individuals that the US sent who are now in a El Salvador prison. Well, this assertion is very important because it might allow advocates who are pursuing strategic litigation in other venues to advance their causes. For example, the United States has itself said, in some cases in the US, that it doesn't have jurisdiction over these individuals because El Salvador has jurisdiction. So this is a bit of a helpful moment when both of the parties are looking and pointing at the other, which can sometimes be strategically helpful, as I said, or at least quite revealing of a strategy. Now, communications, of course, are not binding. They're not findings about violations, except in some circumstances that Professor Gillette will tell you about. But the ones that I send are not findings. They're allegations. So that means that they really depend on broader advocacy and efforts by civil society to make them more powerful and useful. But certainly, I think that communications can be a powerful lever in influencing how human rights are understood and how cases might be viewed. So let me turn briefly to thematic reports. Thematic reports are issued either once or twice a year, depending on the mandate. So my mandate, for example, issues one to the Human Rights Council and one to the General Assembly each year. Now, these can examine new or ongoing problems that fall within a mandate scope, and they seek to give a bit of an analysis based on human rights law, usually, of whatever the issue is. Each mandate holder gets to decide on the focus of their own thematic reports, and they often do this in consultation with civil society, with input from states and of course with expert opinions as well. So you may be able to influence the topics of those thematic mandates by engaging with mandate holders. And I would encourage you to do so. These reports not only highlight key trends, legal developments, and challenges, but they also often seek to clarify normative standards and good practices. So as an example, my report to the Human Rights Council that I presented on Wednesday last week is about the the right of Indigenous peoples to have Indigenous justice systems. And my effort here was to make clear that from the perspective of the mandate on independence of judges and lawyers, it's important that states respect the independence of these Indigenous justice systems. And then the reports also include concrete recommendations that are often, in my case, directed at states, at judges, at the legal profession, and other key stakeholders that might serve as reference points in policy debates or advocacy efforts. For each report, I publish a call for inputs, and these are a call for any kind of submission that might come from states, civil society, the academy, professional associations, or others. Now, submitting an input is very simple, but it's a very effective way to bring your issues to the special rapporteur's attention. And often these, well, normally, if you give your consent, these are made public on the website alongside the thematic report. And so that's another way to get your own perspective on the issue out there and into the public. If an organization is litigating or campaigning on a particular issue, this kind of inclusion or citation to your submission may end up being very helpful to you. Once published, thematic reports can be used in litigation, they can be used in advocacy campaigns, or you could even draw on them for amicus curiae submissions or the like. So in short, when you contribute your perspective, you really help ensure the issues that matter most are considered. And hopefully you can then, in return, draw on the report's findings and recommendations to support your own work. So third and last, and I'll note that it's getting very loud around me, but I hope that you're not hearing that. Mandate holders undertake country visits, which can be useful for strategic purposes as well. So these country visits are usually about 2 weeks long, and they're an opportunity for us to, in a real-time and in-depth manner, assess the situation on the ground in a given state. We meet with key stakeholders, we meet with survivors and victims, we meet with government officials, of course, and at the end of those, we issue a number of specific things. So before the visit, we usually do a call for input again. This is really a chance to bring attention to the key problems. And it's also a way to actually have an impact on the agenda of the visit. During the visit, we meet with all of these folks that I just mentioned. And at the end of the visit, we give preliminary observations. So while we're still there in country, we usually have a press conference where we give our preliminary observations publicly at the end of our visit. Now, afterward, we present a full report, and that's often quite a few months after the visit itself, where we present the report to the Human Rights Council, and the state itself has an opportunity to respond. Country visit reports can be helpful, I think, in a strategic manner because, again, they offer credible, independent findings. They may reinforce factual claims that civil society is making, highlight patterns of abuse, expose structural weaknesses in different systems, and sometimes they also highlight specific cases and often can prompt new communications as well. So the idea here is that they may be useful for you in helping to build the broader context around a case or a campaign and help you underscore when a state is really failing to meet its international obligations. So before closing, I just want to offer an important caveat. First, just all of these tools, communications, thematic reports, country visits, have to be approached both with nuance and also with realistic expectations. So the realistic expectations has to do with you understanding how crucial you are as civil society to making these tools useful. There's a limited extent to which we can make them useful We can, of course, do these formal presentations. As I mentioned, we also do lots of follow-up work by being in touch with civil society and with governments. But if you take the findings of these different activities and push them forward, I think that it's much, much more effective. Now, in terms of realistic expectations, so as you know, we are all volunteers and we have a very limited number of hours in the day, just like you all do. And also, probably like all of you, we tend to be a bit overworked, which means that we sometimes take longer than we would like to come out with communications or to respond to efforts to contact us. So I just want you to understand that and let you know that for that reason, it's often useful to be strategic, and this might involve creating joint communications, for example, or jointly reaching out with a coalition to a mandate. That will often help a mandate holder see that your efforts really represent a larger effort of civil society. In addition, what I want to say is that what I've seen is that when coalitions or networks work together and have a strategy into which a communication or a country visit is placed, it's often just much, much more effective. And then finally, what I will mention is that we also have a lot of informal or kind of interstitial things that we can do. So we can reach out directly to states and seek meetings, diplomatic meetings with them. But we can also do social media posts. And this is something that I've found to be extremely helpful if civil society creates a working relationship with us and can then say to us, well, I know you did a communication 3 months ago in this case. There's an important court date coming up. Can you please tweet about it on this date? That kind of information is often information we don't have in our mind or in our calendar unless civil society brings it to our attention. So I would suggest making that kind of overture to mandate holders when possible. It's extremely valuable for us and often helps us see more effective work as well. So I'm going to finish here and sadly drop off, but I hope that the rest of your discussion is very fruitful. And again, I'm very grateful for the invitation to be here with you today. Thank you.
Thank you, Margaret. Actually, for that powerful insight into how mandates engage with civil society and states, and for showing us that behind the titles and mandates, there is a real engine for accountability at work. And I also agree that submitting inputs is crucial, and it makes you happy when you see a footnote at the submission report. Thank you for that. I think you're leaving. I hope. Okay. Now I hand over to Professor Matthew Gillett, and the floor is yours.
Thank you very much, and it's a pleasure to be here. Thank you for the invite, and it's gratifying to see so much interest. I think that's an important reflection, both of the troubled times we live in, but also more optimistically that a lot of people are rising to the challenge, and that's really critical. And thank you to IAHRAG and all the organizers for bringing this together, because I think it is a time where people have to learn from each other and learn from practices that have worked well, and also learn from errors, different forks in the road that could have been taken differently. So in terms of strategic litigation, I do have some slides that I'm going to share as we go through to exemplify. And what I want to do is talk about the before, during, and after of proceeding before the UN special procedures. You should now be seeing my slide number 1. And what you've got here is actually an image of supporters of Malaysian now Prime Minister Ibrahim Anwar, or Anwar Ibrahim, after the Working Group on Arbitrary Detention released an opinion saying that his detention, he'd been subjected to detention a number of times, was arbitrary in nature and improper. And what's significant with this is that this opinion came out several years, 7 years in fact, before he was re-elected actually to effectively the highest political post of Prime Minister. And it shows that creating that public record, as Professor Satterthwaite just mentioned earlier, can be really important. It can help supporters, it can galvanize them, and it can set effectively the narrative straight, or at least provide a tool with which you can set the narrative straight, because there are external human rights experts who do not have a strong dog in the fight, so to speak, who do not have a vested interest in the outcome, who look at the situation from an objective, neutral viewpoint. So if I move to the next question. I teach strategic litigation sometimes, and at the fundamental level, I think it's important to ask four key questions. Firstly, what are you trying to get out of it? What is the strategic interest and ultimate goal? Whether that is changing the law, whether that is having someone released, for example, whether that is having a policy changed by a government, etc. You then want to ask which forum should you go before? And I'll say a few more words about that in a second. You then want to ask yourself, okay, now that we've zeroed in on a specific forum, maybe one or two, what are the detailed legal positions that we're going to take to best achieve our outcome? And additionally, and these are not necessarily sequential steps, they could all be in combination and cumulative. You're going to want to ask, okay, what are the techniques, extra legal techniques? Now, I don't mean illegal techniques, I don't mean violence or anything. What I mean is public awareness campaigns, building solidarity, interviews, education campaigns, etc. All of these techniques that might help bring attention to your issues. So I said I'd say a few words about the fora. Well, before I delve in detail to the special procedures, there are many other institutions that may work for your purposes equally or perhaps even better. So, of course, don't be blinkered or don't be too narrowly focused in what you're looking at. Think broadly. If you're looking at a situation that appears to be crimes against humanity or war crimes, well, you might think first, what about the International Criminal Court that you see here pictured? There are domestic courts with international crimes under their jurisdiction, such as the Special Jurisdiction for Peace, the HEP of Colombia that you see at the top. And of course, there are domestic courts. I know I'm from New Zealand, so I show the New Zealand Supreme Court there. But of course, in various countries, it ranges to what degree courts may exercise universal jurisdiction. So you may actually be able to hear a case, and we've seen this, of someone who committed a crime in Syria, who's a non-national of your country, but happens to be in your country, and you have solid evidence, and maybe you end up proceeding before a domestic court. So do be open to different bodies. And of course, in the human rights arena, that applies equally, if not to even greater extent. If we think about special procedures per se, you see here a bit of information. In light of the time, I'm not going to dwell on it, but I think this emphasizes that there are quite a large number of special procedures and a significant amount of variety. And also importantly, they are not just limited to what I'm going to talk about specifically in the working group's case, which is allegation letters and our quasi-judicial or quasi-judicial opinions, but there are other advocacy methods that they can take. And in fact, today's activity you could see as a form of advocacy, albeit I'm talking in the abstract, not about any specific case. So the working group itself, you see here the members were actually, we're having a new member from Asia appointed shortly. So there will be a new constellation, but largely the same. And we have a somewhat unique mandate, but we do work very frequently with other special procedures, particularly on torture, working group on enforced disappearance, special rapporteur on freedom of expression, the rapporteur on association and assembly, and several others, simply because of the nature of the cases that come before us. So we tend to overlap. We have what I call the regular communication procedure. I'm not going to test you on the terminology because it's not always the clearest, but that really is our bread and butter, and that you could think of as our casework. It's like regular cases of individuals, sometimes more than one in a case, yeah, sometimes even 15, possibly 20. But it's really a specific case, much like a legal case going through the courts. We then have, and Meg Satterthwaite mentioned this earlier, the urgent appeals and allegation letters, and those letters could concern a specific individual if they're facing imminent risk to life or serious ill health. For instance, if they're on death row, that would be an urgent type of situation, so it's a much faster appeal. If it's a less urgent, then it will be an allegation letter in which the government has 60 days to address the questions that we raise. And it's a genuine allegation letter, trying not to reach conclusions before hearing from the government, but it is a way of bringing to their attention that there is an international spotlight on what's happening. There's also, I'll say a few words about this later, country visits. There's also our annual reports where we can really drill into key issues, thematic issues, arbitrary detention of environmental human rights defenders. That's one we did recently. Arbitrary detention and disinformation, misinformation. It's another one. Mandatory minimum sentences. That really is a key issue for us. So those kinds of topics that we can delve into, and civil society can actually help us working on those types of issues. And we have some longer documents called deliberations, which are more like general comments of the Human Rights Committee, etc. So, opinions. I said I'd talk about these. These are what I mean when I said the casework, the kind of quasi-judgments that we issue. And you see here from a strategic litigation viewpoint, and we're now moving to I've talked about before you're going to engage. Let's say now during your engagement with special procedures, you decide, okay, an opinion is the way to go. Well, this is what it could be useful for. Documenting potential arbitrary detention could be used before national courts. I have seen individuals, when we visited, for instance, Mexico, they would bring the printed out copy and they would say, when my lawyer had this copy in court, it actually helped, and the judge released me afterwards. I don't want to overpromise. It's certainly not automatic, even though we would argue it should be. But it certainly is better than nothing. And we really endeavor to make the opinions well-reasoned, reliable, factually substantiated, and legally correct to the greatest of our ability. These can also be used for advocacy efforts, human rights campaigns, particularly at the international level, and again, ideally should lead to the release of an individual. I think the last 2 years in a row, we've had an increase, reasonably significant increases in the numbers of individuals who are subject of our opinions being released, which is great, but it is still far lower than we would like. I mean, it is short of 50%, and we would like to be far beyond that. And that's why we do really make an effort to increase engagement with governments, quality of opinions, the quality of the information, and that does rely to a great extent on civil society. So you see here a typical example of an opinion from 2023. This is concerning an individual subjected to administrative detention in Israel. And this is just the cover page. But it's an interesting one where he was a youth male, and we ultimately found that his detention was part of a pattern of other young males being put in this administrative detention without being charged for crimes. Because if you're going to be detained, there should be a charge, a criminal charge usually, unless it's a very brief detention. For instance, if there's a sudden danger and people suspect you of something, suspect you have a weapon and have to detain you. And it should be for the briefest possible time to address the security risk and then move forward. And of course, if there is a suspicion that the person is responsible for a crime, well, then they should be charged for the crime and proceedings should ensue. And preferably, they should have pretrial release. But in these cases, many of them were being held in administrative detention without that usual process. We do have 5 categories, and so it will help when you formulate your submissions to think about those categories. We can reorder proprio motu or of our own volition if we see someone's argued a category that we don't see as particularly applicable to the specific fact. I'm not going to go through all of them right now in the interest of time, but I can, of course, return to those during any questions. There are certain criteria required for us to intervene. And so now we're getting into the technical aspects that you would want to work with your client or the person that you're representing. Consent, as mentioned, ideally from the victim. It may not be possible if they're effectively disappeared, in which case the family, and in which case there may be exceptional basis to go to the lawyer. But you usually do want that consent just to ensure that, if the person would actually rather there wasn't an opinion, that they didn't have the extra attention, you wouldn't want to have forced one to be issued, because we as a working group are not really going to be able to go to the individual ourselves to check on that consent in the typical circumstances. So also, we're going to look at, when we're addressing cases, the urgency, the vulnerability of the victims, the quality of the information received, the reliability of the source, have they provided previous submissions, the credibility of the information. Geographic, very important. We want to cover as many regions as the world as frequently as possible. We have a big backlog of cases, so we really have to try and make sure that we don't put all of the eggs in one country's basket and not address other countries. Importantly, there's no need to exhaust domestic remedies, and so that can be quite significant, unlike European Court on Human Rights, for instance. And the state does not necessarily need to have ratified a certain convention. So often we deal with the ICCPR, International Covenant on Civil and Political Rights, but some states haven't signed that, for instance, China, and we will apply the Universal Declaration on Human Rights, amongst other instruments in those circumstances. I'm going to speed up a bit and just say there is more information about who can submit a case here, some formal information about the address that it can be submitted to, some guidance on questions that we will ask. We have a kind of standard form that you can more or less fill in. I've mentioned about consent. I do want to say, okay, so now the aftermath. We've talked about during, and now what about after? Well, at the technical level, governments and sources, so the civil society, will be asked to inform us within 60 days about within 6 months, sorry, about any action taken to fulfill the opinions. And so that information is really critical for us to keep up with what's happening. And sometimes governments and possibly sources could dispute, and they could request a review of one of our opinions. For example, if some entirely new facts came to light, which were obviously not reasonably foreseeable or not reasonably known at the time that they submitted or responded to the original application. Beyond the opinions, we do also engage in country visits. You can see one here, during which we'll report good practices, but also bad practices. You can see here actually an example of quite a positive practice from Mongolia, where people were in mental health facilities were phased out of those facilities by staying in these more traditional semi-independent tent structures where they could relearn to integrate into society and eventually be allowed to live in society fully. So country visits can be a very important way of us advocating with the governments directly while there, and also meeting with civil society and hearing about their concerns on the ground. So those were a very rapid few words about the use of special procedures for strategic litigation. As a concluding point, I would just say that do think through the process, do talk to people, do ask questions, but also don't hesitate when you feel that there is a case that needs to be progressed, because It really is that wrongdoing prevails, to paraphrase, when good people do nothing. And so, but on the contrary, if you raise a concern, you might not be able to do everything yourself, but others may be able to join in the effort. And there's no ownership in these. I mean, I think we're all working towards the same purpose, which is adherence to human rights. And so, don't hesitate to bring people on board and reach out for help when it's needed. So thank you very much for the attention, and I'll pass back to you.
Thank you, Matthew, for outlining really such a clear and structured approach to engaging with the special procedures, especially working group on arbitrary detention across different stages. It really highlights how timing and preparation are just as critical as the content itself. And you have also reminded us that even soft law can hit hard if used strategically. And finally, I have the pleasure to give the floor Dr. Elodie Tranchet. Elodie, the floor is yours.
Thank you so much, Ali. Or maybe I should not thank you because you're giving me the floor after two of the most brilliant minds of the UN Special Procedure System, and you're making my life hard. But since I'm a huge enthusiast about special procedures, this may actually compensate. And I also have prepared a few slides that I'm gonna share right now. And I believe that at this stage, you see my screen. So the idea of my presentation is really to answer this question: why special procedures matter for litigation? And when we talk about litigation, strategic litigation, well, we know we often refer to this idea of making use of legal action, not only to solve one specific case, but to create a broader social impact, to create political change. And it's extremely powerful in the frame of human rights and social justice, to focus and to shine light on systematic violation, on holding power accountable, and also on opening up, some political spaces. So when we talk about litigation, I want really to focus that it's not happening only in court, and it's about, like we've been seeing with Margaret and Matthew, it's about leveraging together legal tools, public pressure, and also institutional support. And this is when special procedures are actually coming in. Before, during, after the process of litigation, well, we are talking about an entry door and helping victims, helping practitioners, to shape the narrative, to mobilize support, and to legitimize sometimes the demands. And what we are going to see, and it's been developed by Matthew and Margaret, they are fast, they are accessible, and they are, in many cases, the only mechanism available when everything is actually feeling blocked. And I like to use the metaphor of the orchestra, So think about the UN human rights system, but also beyond the UN human rights system. I mean, human rights, like Human Rights Council, like Matthew has been saying, we have to think out of the box. Imagine that the system is a giant orchestra. So you have the very powerful players. So I don't know, maybe the first violins, the first cellos would be the domestic courts, the European Court of Human Rights, even the treaty bodies. But what would be the symphony without the triangle, without the flute? So every instrument, however small, matters. And it's true that the UN special procedures may seem somehow light in terms of formal power, but they can change the rhythm, they can introduce new notes, new nuances in our symphony, they can amplify the silences. So exactly like in an orchestra, each mechanism is relying on one another, to create harmony. And you, the practitioner, you are the conductor. So you take the list of questions that Matthew were presenting, and you identify which instrument should you use at which time. You should ensure that when using one mechanism, one instrument, it is actually creating more persuasion and harmonious composition. So as Matthew was saying, in view of the large coverture of special procedures as of today, there is virtually no human rights that cannot be covered by special procedures. So 46 thematic mandates, 14 country mandates, some focus on torture, freedom of association, expression, housing, water, education. Thank you, Matthew, for bringing the working group on arbitrary detention, other working group with different working methods. So they offer accessible and direct remedies in the UN system. And I really want, it's not because you're here, Matthew, but I really want to pay tribute to the working group on arbitrary detention, because in many of the cases we are following, the mechanism is really the only beacon of hope for many people, notably in cases of political prisoners, in case of systemic persecution, abuse in authoritarian regimes. And your opinion are very, very often bring hope and legitimacy. And we may think about very powerful cases, those cases that brought a lot of media attention, like the case of Julian Assange. I believe that the working group on arbitrary detention opinion has been key, in the whole process, or, situations that looks like black boxes, the Guantanamo case, Abu Zubaydah, So the working group on arbitrary detention introduce a form of accountability, and states cannot easily ignore the opinion of the working group on arbitrary detention. And so I love special procedures in terms of my orchestra, because they are actually agile, they are fast, they are flexible. Agile because urgent appeals can occur even in-house. It can be very quick, very flexible. I mean, they accept informal evidence, sometimes even publication on Twitter, pictures, very flexible and very accessible. As Matthew was saying, no need to ratification, no need for exhaustion of remedies. And also, I really love the fact that special rapporteur lately engage a lot in social medias. Like Margaret was saying, we see a lot of special rapporteur making use of X, to leverage the work of civil society. And beyond this agility, beyond this accessibility, the special procedures have a real reputational impact that we cannot overlook. States, they care about their image. And when a country is named in a special rapporteur annual report or in an interactive dialogue, a public communication, well, it stings. It becomes part of the UN record. And this mention would trigger diplomatic concern, sometimes even press coverage, and if you do your homework, also parliamentary question. So they really help human rights defenders, to draw attention on situations that could be totally ignored, totally out of the radar, And what is key is to build on the special procedures outcomes. Okay, so from soft law to strategy. So the special procedure findings can be used both in domestic fora, but also in international proceedings. So they can be quoted before treaty bodies to support claims, to reinforce the factual record, to push even like we've done in the past for interim measures. And going back to the orchestra metaphor, very important to think complementarity. A few years ago, when the Gambia brought the first erga omnes case before the ICJ against Myanmar, it was very impacting for me to look at the footnotes of the initial request of the Gambia, full of reference to the fact-finding mission that was set up by the Human Rights Council. Of course, Commission of Inquiry, fact-finding missions, they're not special procedure, but somehow they are similar. But also, like very recently, when South Africa brought Israel to the ICJ, also based on this erga omnes genocide convention, very striking, the dozens of references to the special rapporteur findings, including, the one from Francesca Albanese. So these references and this work of the special procedure, it's not decoration. It's not cosmetic. It's coming with moral weight. It's coming with a legal influence. And something that Margaret has been quickly touched upon, and I think very important, is to bring also special procedures to pure litigation, bringing special procedure to courts. And here, I want to bring one very interesting and amazing strategy, I would like to say, developed by the victim in Turkey of the Gulen movement. It's been 9 years now that they are systematically engaging with the UN mechanism, gaining critical support. And very recently, they managed to get on board the special rapporteur on human rights and terrorism to appear as a third party in this hopefully landmark IAHRAG case before the Grand Chamber of the European Court of Human Rights. The fact that Ben Saul accepted to take part to this case, it is actually bringing legitimacy depth to the case, and even international attention and scrutiny to a case that may otherwise be, in the shadow. And also special procedures, I believe they are in this kind of position in between the victims, in between the states. They are somehow mediating or acting as translators. So they bridge the experience of victims with, the formal language, the legal and the diplomatic language of states and of institutions. So they can even reframe those injustices as systematic failures. And with the communication, like we've seen with the country visits, they open channels of discussion, of dialogue. They identify the pattern, and they really bring some balance to, the disproportionate powers that we have between states and victims. So they don't solve everything, but they often create space when we don't have before. So in terms of conclusion, what I would like you to take away from this, well, clearly, special procedure should not be seen as the last wheel of the last wagon, as we say in French, la dernière roue du carrosse. They are truly crucial. They help to open doors, to tell stories, to build pressure. When we engage with special procedures early, with focus, with evidence submission, they make a real difference, although we have to manage expectation, like said by Margaret or you, Matthew, explaining that an opinion does not equal automatic liberation. We've seen it too many times, but still very important to develop an overall strategy, not relying on just one path, as we've been saying. Besides the UN system, very important to engage with court, with the media. And yes, special procedures are among the best tools that we have in our toolbox, to address injustice. Thank you so much. I give you back the floor, Ali.
Thank you, Elodie. Really, your metaphor of special procedures as an orchestra, where each mandate adds a distinct note to a broader advocacy score, beautifully captured both the potential and the precision required in the strategic litigation. And also, I remember the Special Rapporteur Bensol's third-party intervention before the European Court of Human Rights recently, and it was a significant contribution for the Yalçınkaya case versus Turkey, which impacts, I think, hundreds of thousands of people, and we will see what happens shortly. And now we will proceed to QA session, but actually feel free to submit your questions. We will ask them as many as we can actually at the end of the session. But before we open the QA session, I'd like to begin with a few questions of my own. My first one relates to the strategic use of special procedure mechanisms. From your experience, what would be some key tips you'd offer to practitioners looking to make effective use of the United Nations special procedures as part of a broader advocacy or litigation strategy? Thank you.
I can offer a few words first. Absolutely. So I think it's going to help to know what the special procedure does. Of course, sometimes it's quite specialized knowledge, so don't presume that you have to have a PhD in this area to understand, of course. But I think at least reading through the publicly available information on the website to understand the broad framework, and if it's attending meetings such as this one, will help so that, for example, I mean, I can think with our group, if suddenly there are a whole lot of allegations that are really about, right to education, for instance, or something that doesn't squarely fall within our mandate, then you could potentially disappoint your client by saying, oh, look, we've got all this great material that we've included, but then something comes out at the end that just doesn't really comment on that at all and ignores it effectively. So I think understanding what can fall within the mandate helps. Another point in a very practical perspective is writing the facts clearly. I think most of these cases that we deal with, and most situations come down to the facts. And it's relatively rare that something presents a completely novel legal challenge, because most of the laws are relatively broad and developed, and yeah, of course there are new legal issues that occasionally arise, but many of the issues have been dealt with before, and the difficulty, the challenge is really understanding the facts. So if the facts are written quite clearly and obviously you're researched well and understood well, that's going to take us a long way. And you know, often I take the approach of empty your pockets, you know, just reveal the situation as it is. A person does not need to be a perfect angel in order to be found to have had their rights violated. Now, I'm not saying you need to incriminate your client or anything, but I think the more just frank and factual on the details and the history you are, the easier it is for us to understand the situation and what's happened. And then the easier it is to issue a clear and sort of more, I would say, robust opinion. So yeah, thank you very much for the question.
If I may also jump on what you said, Matthew, I'd say really learn how to navigate the IAHRAG website. I know it's not easy, but there is this database of the communication of special procedures, you know. As a nerd of human rights, I have a constant look, you know, on the recent allegation letters that were sent. This is, for instance, how I discovered that special rapporteurs were also sending, you know, allegation letters not only to states, but also to private actors. So let's imagine you have a case regarding censorship of a journalist. So you ask to the special rapporteur on freedom of expression to go after the state, but also to go after YouTube, to go after Meta, after X. So this is a kind of thing that is very important. And by, you know, reading these allegation letters, this urgent appeal of special procedures, you will know how to frame your cases successfully. And something that is key, I would say, I know that when you're not based in Geneva, it's not that easy, but establish contact with mandate holders. Most of them are extremely keen to meet with civil society. If it's not in person, it's on Zoom. Do not even overlook the assistant of the mandate holders. Sometimes they may be even more powerful, you know, than the special rapporteurs themselves. And as you said, would be also good, you know, to identify which mandate holders are the most relevant for your case. I mean, don't fish too broadly. Identify also which mandate would take the lead on the case, you know, and target your effort on meeting the assistant and the special rapporteur, and definitely tracks the communication, especially when it's an urgent, an allegation letter. It will be published 60 days after it's been sent. Most of the time, we practitioners, we are not receiving any notification that it's out. So it's very important then to amplify, to bring into the media. What I do also is that if it's a high political case, I bring the media on the line, like we submitted a case to the special procedure. And since the media know nothing, they go, the UN is involved, you know. And so you gain a bit of pressure.
Thank you for both those invaluable answers. And actually, I have a second question, if I may, actually on risks and limitations. So for you, are there any risks or limitations you would highlight when using the special procedures, including for sensitive or high-profile cases?
Okay, I'm happy to kick off again. I mean, the primary risk has been identified, which is reprisals, retaliation against the victim or detained person or subject. And so that has to be carefully balanced. It really does. And it's quite a context-dependent assessment. If there is retaliation, and let's say, for example, the client gives consent to the activity, but then some kind of incident occurs and it appears to have been in relation to them utilizing the UN procedures, well, that is also something that we would follow up on and condemn quite strongly, because everyone has the right to bring their claim before special procedures, and they should not be punished for doing so. So that's the main risk. I think with any strategic litigation, there can be risks of adverse findings. That's always there. I think we've seen in other cases, for example, in the European Court of Human Rights, there's been cases brought, for instance, with the ban of the veil, I remember in France, and then that resulted in some ECHR jurisprudence that is actually now being used by other countries beyond France to impose prohibitions. So if you saw that as an instance of strategic litigation, then you'd have to be aware there can be kickbacks, or let's say knock-on effects, and it won't necessarily always go the way. I mean, obviously that's the thing with having independent experts, is that we will bring our independent minds to the situation. I should highlight there are situations in which people are properly detained. I mean, if someone is a violent threat to society, they will likely have to be detained, and that's not a violation of human rights. But in many of the cases we see, it's not that paradigm. It's someone who is a political opponent or a human rights defender, or has expressed their views on an issue. We had one recently. He just expressed, he was not at all a public figure. He just expressed concern about the way that workers were being treated in the lead up to the last Football World Cup and being exposed to dangers. And for raising his voice, he was suddenly detained for essentially 2 years as a very ordinary, I could say, person. And so that was entirely arbitrary. There was no need for him to be detained in those circumstances. But yeah, those are the major risks I'd highlight. Thanks.
Yeah, thank you, Matthew. I was also about to bring the case of reprisals that we always take into consideration when we bring case to the UN. Although it is true that the special procedures, it is my understanding that they don't reveal the name of the source. But I mean, if it's an individual case, they would have to tell to the state the name of the victim. So, but I had in mind maybe something that is good to remember when it comes to working group on arbitrary detention opinion. They may constitute an obstacle for bringing the case then to the European Court of Human Rights. So the case law of the European Court of Human Rights is very clear with Peraldi, although I believe it's not a good case law, and I've been fighting for a change. But the work at this day, the European Court of Human Rights would not consider you claim if you already got an opinion. We have in the pipeline, I believe, a decision from the Human Rights Committee that would clarify the status of the working group on arbitrary detention opinion before the Human Rights Committee. It would be very useful. You mentioned the case of the veil. There is a big fight between the Human Rights Committee and between the European Court of Human Rights, with having even, conflict of interpretation of the same norms. So it would be interesting to see if the committee is taking another look at the situation. So this is mainly what I had in mind at this stage.
It's a really good point on the strategic side. Absolutely, Elodie. Thank you for raising that. The devil's in the detail sometimes, and we have this paragraph 33D provision in our methods of work in the working group, which states that if a case, the same case, has been brought before another UN body or is before another UN body, that we should, and it's brought before us, that we should transmit it to that other body. So it's effectively a rule of comity, a rule of ensuring that you're not working at cross purposes. I would say the European Court, from what I've seen, is even stricter than that, in the way that it crosses from a regional body to a UN body. And of course, the European Court is inundated with cases, so they will be looking for reasons to strike out claims effectively, or render them inadmissible. And it is a complicated area, so it's something to be aware of. I do think that my advice is always go for the body that feels the most applicable first. Don't just take the machine gun approach of let's send this out to every possible body, because again, the people working on these cases, there's also an interest in not having all of the human rights bodies all addressing the same cases. So a sort of distribution of work principle, you could say. But then again, if you're bringing a different case, even if it's involving the same person. So, for example, when I mentioned, right to education, or there could be a sort of migratory right, etc., that you may have a case before a human rights committee. But then if in our case you were focusing on the detention side, and so they were factually distinct, then it wouldn't bring into play that potential application of paragraph 33. But it's a really good technical point to be aware of.
Thank you a lot for those answers. Actually, I had another question, but actually I sacrificed mine because we have 20 minutes left, and I see in the chat we have 5 questions, which are really timely and relevant. And now I would like to proceed to QA session, if I may. And I thank you all for your thoughtful engagement. I do my best to get through as many as possible. But actually, our first question comes from Sara Pinto Oliveira. And she asks that in contexts where victims may be afraid to give formal consent due to fear of retaliation, surveillance, how can advocates ensure ethical reporting while still promoting proactive, protective mechanisms when rising awareness of abuse? I think Mativo or Elodie.
It's a good question. Thank you, Sarah. The challenge, and Elodie mentioned this before, I mean, in the context of detention, and I realize your question might have been directed to me. In the context of detention, the government needs to really know who the detainee is so that they can then go and check on the facts of the case. We have had examples in the past. I sometimes read back to really old opinions from the 90s and things. And there were cases where the person had never been detained, for example, or it was a misidentification. So they do need to know who the person is for our purposes. Now, what you could have is an allegation letter, or it would be an other letter, technically, addressing the practice. If you really couldn't name the detainee or the victim because of that risk, but there was a sort of practice that was more generalized, that's the kind of thing. And other letters, typically it's legislation or policies that we would address. And the other way would be if you raised a case with a different person but had been subjected to very similar treatment, then maybe generating an opinion in relation to that person, and maybe that person has already been released, so they're no longer at such risk. But you could use some of the findings to then go and advocate on behalf of the person who's still detained. It's possibly a sort of slight workaround. But yeah, thanks.
Yeah, thank you, Matthew. This is what I would have done as civil society, identifying the systematic pattern and bring this as a systematic issue, But it's a complicated case indeed, yeah.
Thank you. I think, Sarah, that is a satisfying answer for you. And if you have any question, please feel free to send an email us, and then maybe we can get back to you as soon as possible. Our second question is from Sener, and he has a question for Mr. Gillett. Recently, authors submitting communications concerning violations in Turkey following the July 15 coup attempt have begun receiving replies indicating that Working Group on Arbitrary Detention will not examine their cases through the regular individual complaint procedure, but will instead consider incorporating them into an allegation letter. I'd like to learn more about the Working Group's policy and practice regarding such cases, particularly in situations involving widespread violations occurring in similar context. Wow, very particular question, I think.
Yeah. I mean, I have to be slightly guarded on what I say, but what I can say is that simply we've had a lot of cases coming from this context. I mean, there's not, as far as I'm aware, there's nothing more to this. And I should say I haven't personally written these emails, so I am proceeding. Let's say, take it with a grain of salt, what I'm saying. But it's as I understand it. simply because of the number of cases coming and that we do have a major backlog of cases. And because we've issued many opinions in this context, we're looking at ways to try and, as expeditiously as possible, address as many of these scenarios as possible without basically the delays that are going to inevitably happen if you have to wait for a individual opinion. And that's a really difficult balancing equation that we sometimes have to make because, again, we get submissions from context all over the world. And at a certain point, if we've addressed a context in relation to many individuals, we start to look at the potential diminishing returns of continuing to address the same facts again and again with more individuals. And instead, and I should say highlight, look at the possibility of putting them into an allegation letter, which is more agile, to use that term. It's faster. It doesn't require us to all meet as a group of 5 in order to assess. So yeah, that I suspect what the main reasoning is.
Matthew, as a follow-up question to this one, would you recommend to a civil society to actually organize and maybe submit joint communication when we have, this situation when you've been addressing again and again and systematic issues, so maybe to ease your work, instead of having one lawyer sending the case of Mr. X or whatever, we join them, so we come with the individual facts and we highlight the systematic pattern? Would it be a good option, strategic option?
Yeah, I've seen that approach taken, and it does, from my experience, make the process more efficient, faster. I mean, yourselves will understand the facts probably better than anybody, and so it can make a lot of sense to do that. But of course, everybody, is independent and free to proceed the way. I'm not going to straitjacket anyone into taking a certain approach, but as a practical matter, I think that could be quite wise.
Thank you. Actually, we have another question, I think but actually I quote from Diana Bertucci. If I'm wrong, Diana, I'm sorry for the pronunciation. Good afternoon, thanks for the presentation and very useful. My question would be, made an application, if I have made an application to the working group on arbitrary detention and I haven't heard back, what steps should I take for feedback? The application was made last year. Does the working group have a system to follow up for updates?
Yeah, I think that question's for me. I'll take that. So yeah, it's just unfortunate the number of submissions we're getting, and obviously conflicts around the world are not diminishing in number; they're increasing, and plus there's election connected detention. There's all kinds of ongoing. So it is an issue that it's just taking a lot longer than we'd like to get through all the cases. And unfortunately, your experience is not unique in that respect. I would say after a reasonable period of waiting, that sending a follow-up email to inquire can work. But again, it's a matter of balancing all of these factors of geographic distribution, urgency, emblematic cases. We had one where it was 6 youths sentenced to death in Saudi Arabia late last year, and that was the kind of case that we are going to try and find a way to address as fast as possible. Versus if someone's been subjected to bad detention, but they've been released, then we can still address it, but it's probably not going to be as urgent typically. So yeah, these are the factors, and please do, after a reasonable period, try and follow up to find out from us what the possibility is of it proceeding. Thanks.
Thank you, Matthew. And the next question is, can you talk a little bit about how special procedures address factual disputes in their analysis, either when a state party is participating and explicitly disputes the facts, or when publicly available information either calls a submission's description of the fact into question or provides additional facts that may change the legal qualification?
Okay, excellent question from Arthur. Thank you very much. And I'm sure I know as an experienced litigator, Arthur, you'll be very interested in these issues. And so um, it is a challenge because the parties, the government, are limited to 20 pages really of submissions. And within that, especially if you've got quite a complex scenario and maybe like terrorism allegations, etc., you do sometimes get divergently or diametrically opposed narratives, just two totally different narratives. And so yeah, our job as experts, and we all have quite a lot of experience. I should say my colleagues, for instance, the chair of Ghana, she was a judge in the European Court of Human Rights. Mumba, he's the president of the Supreme Court of Zambia. Miriam, she's got long experience in Latin America. And our new colleague, I'm sure, will as well from Asia. And so we will essentially take our experience. We, as a group of five, will look at the facts and we will be assessing which is more convincing. And to do that, we will be looking at factors such as if the source has raised quite a specific allegation. For instance, let's say they've complained that they requested provisional release or pretrial release, and their claim was never addressed, wasn't even assessed. And if the government just doesn't address that, if it skips past it, or if its response is very perfunctory, like under the legislation of our country, a request for pretrial release is always addressed, but they don't provide any more details, well, that is going to indicate typically that the source's account seems more detailed, seems more credible. The government has the information in its hands. I mean, it certainly should, because it's the one running these processes. So those are the kind of factors we're looking for, but also internal consistency of the submissions to make sure. I should say one point, and just because of home issues, I have to run to pick up my son reasonably soon. What I can say very quickly, because I saw a couple of questions written, and I can say on Annabella's question that the follow-up procedure is, well, we ask for information within 6 months from the government and the source as to what's happened. And if there hasn't been a release, for instance, and that does happen quite a lot, we can then write follow-up letters to the government to ensure, and we can essentially report on that, and also through our annual reporting to the Human Rights Council. And again, as mentioned earlier today, governments do not enjoy being reported on in those circumstances. In relation to Fergus's question, I don't want to be misunderstood. It's not necessarily close to 50%. And it's hard to give an exact figure. I would say it can vary between a sort of 15, 20% up to 40%, depending on. It's also a very difficult calculation to make in the quote success rate, because sometimes people are released early for different reasons, and governments rarely, if ever, have said explicitly it's because of an opinion. But often what we're seeing, which is heartening, is pretty shortly after an opinion being issued, an individual being on a list of pardons or royal prerogative releases. And so that gives an indication that there's quite a coincidence in time and sequence of events that we will look on that positively. And again, the main thing for us is which way is the trend going? So even if the measuring is imperfect, if the trend is going up and we're using the same measurement technique, then that is a positive indicia. Yeah, and so in terms of, I think those were the questions that I saw directed to me. So I may have to pass to Elodie and
Yeah.
yeah.
Thank you. And I understand you have to run, but Fergus, I was very interested by your question on like how to make more creative to ensure that special procedure, but also sometimes duty bodies members. And also maybe, I know you have to run, Matthew, but from a civil society perspective, it's been a while that I'm longing, you know, for more involvement from civil society in the nomination of experts of the Human Rights Council. You know, the process is highly under the supervision of states with the 5 ambassadors, and then with the president nomination. I've seen that the OMCT is somehow helping civil society to get in touch with some candidates, but it would be very good to sit together, civil society and also experts, to see how we can evolve the practice. And I understand that the DNA of the system, it's an interstate body, all that, but it would be very interesting to see how we can push for civil society recognition. See you.
Thank you, Lady. Maybe just a last question for you. Could you share a real-life example where using the special procedures led to a significant progress or tangible outcomes, whether legal, political, or symbolic? Maybe that will be my last question before we finish and hand over to Ricardo.
Well, I have many in mind. I mean, currently I've been working on the case of Chagosian people, but it's ongoing. I believe the case of the Marshall Islands would be extremely interesting because it's a very innovative way of using special procedures, mainly also to leverage, you know, political pressure from an interstate perspective. You may know that there is an ongoing dispute, you know, between the Marshall Islands and the USA regarding the nuclear testing that took place between 1946 and 1958-ish. And, you know, this had a huge impact regarding environment, regarding right to health, also regarding displacement of population. And it was so interesting that the Marshall Islands have opened, you know, a standing invitation to all special procedures, notably the one on internal displacement, but also the special rapporteur on hazardous substances. And based on this effort, this time, you know, not from civil society, but also from the states, this made a huge difference in leveraging, you know, negotiation with the United States. Marshall Islands, I've been playing the orchestra using special procedures, OHCHR reporting processes, and right now it is supported by the OHCHR process. So I believe Marshall Islands made a super interesting case. And just to go back to the Chagosian people, just to let you know that Chagosian people managed to get very recently a very strong allegation letter in a very quick way from the special rapporteur. The issue was on 22 of May, and they got a communiqué de presse and an allegation letter very quick on the 10th of June. It was interesting that the next day after the special procedures issued the communiqué de presse, there is the Attorney General of Mauritius that made a public denunciation of this communiqué, saying, no, this is nonsense. And I think it's interesting because if it was nonsense, if it was useless, why do you take care? Why do you take the floor to say it? So I believe it's an example, a typical example that demonstrates that it is working. For what it's worth, it is working, not having delusional aspiration or expectation, but creating a reasonable amount of pressure. This is working really. Yeah.
Well, thank you very much, Radi, for this answer. And I thank you all for your excellent questions and thoughtful engagement. It's been a very rich discussion, also actually for me. But before I finish, I would like to briefly highlight another upcoming panel by IAHRAG entitled More Than Monitoring, Exploring the Rapid Response Powers of the United Nations Treaty Bodies. And actually, this event will dive into how treaty bodies can respond more proactively in urgent human rights situations and how civil society can make use of those mechanisms. We will be sharing more details in the coming weeks, and we encourage you all to join us for that important conversation. And to close today's panel, I'm now pleased to hand the floor back to Ricardo Espinosa for his final remarks. Ricardo, over to you.
Thank you, dear all of everyone. Thank you to everyone. Of course, mainly to our impressive panelists, and really a big thank to Ali for his excellent moderation. As said before, this is the first session, our public experts series on international human rights mechanisms. But as you said, Ali, it's not the last one, and we'll continue hosting discussions like this. So please follow us to stay informed. I have learned a lot, and certainly next time more and more. And thank you again, and we hope to see you again soon. So bye-bye, and have a nice summer. Thank you.
Thank you very much, and all those comments in the chat. Now I close the session. Bye bye.